to Unpublished Opinions, an Institute for Justice Roundtable podcast. The podcast where Institute for Justice attorneys get together and give their unvarnished and unpublished opinions about the law. I'm your host, John Wrench, the Assistant Director of the Center for Judicial Engagement at the Institute for Justice, and we're recording on Thursday, the 13th of February, 2025, and today I'm joined by two of my most beloved colleagues, senior attorneys Diana Simpson and Josh Windham.
Hello,
Diana
John.
and Josh, welcome on Unpublished Opinions.
Thank you.
Hey, good to be here.
So one thing that Diana and Josh have in common is that both of you have experience litigating in state courts, which have their own rules of civil procedure. So things like rules about filing the lawsuits or briefing, or about discovery and arguments and things like that. And although some of those rules are quite similar to the federal rules, some of them are quite different. And so, Josh, just to start with, I was wondering whether there's any unusual state court rules or practices that you've run into, and if there's any of those that you particularly liked or really disliked.
Let me start by disputing the premise of the question, because the premise of the question is that state courts have rules. And I think one of my biggest gripes is that there are often not rules. It's like a common refrain among state court practitioners who also have federal court experience to say that state courts are like the Wild West. That is definitely true. I will maybe just highlight a few of the ways that I have been sort of vexed by state courts' practices or lack thereof in recent years. So one of the most telling disparities between state court practice and federal practice is that when you file a lawsuit, there just aren't schedules that kick into place. You know, if you file a federal lawsuit, there's like all these procedural benchmarks that kind of, as almost like a ticker, just kind of pop into place, right? The parties have to confer. You have to kind of propose a schedule to the judge and make some basic disclosures to kind of kick the discovery process off. And there's typically a case management order that gets entered that sets up kind of a schedule for how the case is going to progress. And that's all really nice. None of that happens in so many state courts. I have not practiced in every state. I've practiced in, a good handful of states. So I can only speak to those experiences, but I've been frustrated, shall we say, about how slow things can move when you don't have those kinds of schedules in place. And, how difficult it can sometimes be to get practitioners in state courts to agree to put those kinds of schedules in place because they are anomalous in their experiences. So that's kind of the big one for me. There's a few others I want to mention. So one that I've noticed across a few states now is that motions and briefs are often dissevered from one another. So, a party can file a sort of pro forma motion to dismiss that says, we're moving to dismiss under Rule 12b1 and Rule 12b6, pretty common. Then you won't get the briefing for like a while after that happens. And in some states, briefing isn't even required to served on the other side or the judge until like 2 or 3 days before the hearing is set in the matter, which is just kind of wild. If the judge doesn't have enough time to read the briefs, how is the judge going to be prepared for the hearing in the matter? So that's always kind of vexed me. And then finally, I just want to put a finger on South Carolina as a particularly bad state for civil procedure and appellate procedure. Just to give you two examples of that. Actually, I'll start by saying that I have a case in South Carolina that I filed in 2016 that is that's still going on. We are now before
your case is like a third grader now.
It's wild. It is as old as my legal career, and that's we're 8.5 years now in. Just to give you two examples though of how procedure in that case has frustrated me. Number one, we've had a situation recently where we had to double MSJ brief, so file 2 separate rounds of summary judgment briefing and 2 separate summary judgment briefs because the judge who was assigned for the first round of summary judgment briefs just sort of retired and told nobody. And so after like 6 months passed and nothing happened, we inquired and said, hey, can we get a hearing? And we were informed by the clerk of court that, lo and behold, that judge didn't exist anymore. and we needed to go find another one. So that was frustrating, and who knows how long that would have gone on if we hadn't asked. And the other point I want to make is that appellate practice is particularly odd in South Carolina. When you file, you have to file an opening appellate brief that is designated an initial brief. Same for your reply brief. They're all initial briefs. And then the record is compiled. And then the parties go back and file their, quote, final versions of those briefs, inserting all the finalized record sites into the initial versions of the briefs. And you can't change anything else. And so what ends up happening is that the final briefs have different, like if I cite my opponent's brief in my initial briefs, I can't change the citation. So my final brief citations to their briefs will be wrong because the pagination changes. And it is the rule that you have to keep them the same. So it is deeply frustrating. And that is my kind of opening foray.
I will see your South Carolina and I will raise you a Texas. And which I know that, and Josh, I know you've litigated in Texas before, but I wouldn't call it bad necessarily because there are lots of attorneys in Texas who are very used to the Texas style of practice. And I'm not one of them. I go in there and I'm very clearly an out-of-stater. I don't always appreciate the differences that they operate. But one example is when you have a case at SCOTEX, at the Texas Supreme Court, you don't actually have it at the Texas Supreme Court before you do all of your briefing. So you file your petition for review, and then you also file a merits brief, and then the court decides whether to take your case or not. And so by the time the court has decided to take your case, it's already like the parties have already paid for very expensive lawyers' time, right? Like it's not just a 5-page PFR. Now you're talking about all of the merits briefing. And, for litigants, for parties, I guess, who are paying their attorneys, to me, that's like a real harm that they experience that is not the case in other states. At least, SCOTUS, when they decide to take a case, they tell you it, and then you write the briefs. It's not just writing the briefs ahead of time.
Do you think it's designed, Diana, to sort of dissuade people from even trying to appeal unless they feel like their case is super strong?
I don't know. And I will say I'm on another concern or experience in Texas that I have that's different than kind of other places I've litigated. It's like an actual big problem in one of my cases right now is that basically the government can take an immediate appeal of an MTD denial of the state court version of the motion to dismiss. Can make it an immediate appeal and then stay the trial court proceedings and then just add on a year, 2 years, 3 years to the length of the case. And so when you're talking about, just an ordinary businessman or an ordinary property owner who's just trying to resolve an issue, all of a sudden litigation has to take 5 years or whatever because they've filed this case. The government comes in and says, oh, I'm immune, or, oh, I've got some other kind of government trick that means that I win and you lose. And then the trial court says, no, that's not true. And they say, okay, fine, I'm going to go ask somebody else first. And then
are you talking there about Texas's plea to the jurisdiction procedure?
I sure am.
Yeah. The thing I found frustrating about that when I litigated in Texas is that it's like this amorphous tool that the defendant just sort of has to sneak in pretty much any argument they feel like sneaking in at any time in the case. I mean, It's truly bizarre.
Yep. And the problem that I see is that they can take this immediate appeal and stay the trial court proceedings. And so at least with, when an MTD is pending in federal court, technically you can still, discovery is still supposed to be happening. And so all of that kind of can continue while the court figures out whether the defendant is amenable to suit. And, it's very frustrating and it takes a long time. And the government can just make whatever bogus arguments they want to make. And like there's not even a check on it. It's just like, oh, yeah, they can take their appeal if they want. And then they can, once they lose at the appellate court, then they can ask the Texas Supreme Court for review. And then once they lose there, then you're back down to the trial court. And to go along with Josh, with what you were saying before about timing, there's not a limitation on this. They can do this basically whenever. They can file their plea to the jurisdiction. They can also do it when they file a motion for summary judgment. And so they can just indefinitely delay the case, causing ordinary litigants to spend just an enormous amount of money defending themselves. It's messed up.
We had a case in the Michigan Supreme Court called Maxson about drone surveillance. And I wasn't on that case, but my memory of of the procedure there was that Michigan has like a similarly quirky thing with their state Supreme Court where you do all the briefing, all the way through merits briefing before the court even decides whether it wants to grant. And then they have this like bizarre form of oral argument you do where it's like half the length of a merits argument after they've granted review. And that argument is for the sake of deciding whether they should grant review.
Oh my gosh.
And so you can even like get to the point where you're arguing before the court, as we did. And then they'll say, oh, we'll grant, and then maybe we'll decide on the merits, or maybe we'll have another argument. It's truly, like, one of the big themes here, I think, that we've kind of hit on is that things are inefficient and duplicative in state courts. And again, that often stems from the fact that there just aren't real procedures or structures in place for litigating civil cases. John, you litigated in Iowa up to the state Supreme Court recently. Did you notice anything bizarre about Iowa's procedures?
I wouldn't say in the trial court process there was much that was strange. I did like the slightly different versions of all the names of the documents, right? So it's a petition, not a complaint. It's a resistance, not an opposition. But outside of that, it was pretty straightforward. They did have an interesting procedure for when you appeal, because you have the option of appealing directly to the Iowa Supreme Court after there's been a final judgment in the trial court. And the way that you do that is you file your merits briefs to the Iowa Supreme Court. And it's kind of the procedure that you were talking about, Josh, where you actually have to file 2 stages. You file a proof brief, which it doesn't have the appendix citations, and then you have to file a final brief, which has the new citations in them, which it's not like it's a complex addition of work, but it is just an added step that it just doesn't make much sense to do. And I actually think that they just changed this past year. They got rid of that rule. So I imagine that enough people either complained about it or the justices themselves were thinking, why do we do this instead of just, having the appendix citations and filing the brief then? But I agree with everything that you've both been commenting on. It seems like a lot of these systems in the different state courts are not designed with the cost of litigation in mind for people who may not be able to afford years and years of prolonged litigation, or even, the minor briefing changes. Attorneys are going to spend time on that. People are going to have to pay for it. So everything that I think, if I'm remembering this correctly, I think everything both of you have mentioned is negative. Is there anything positive that you've experienced in a state court that's a procedure that you like or would actually like to see kind of standardized, or is it really just bad variations?
I would say that I have enjoyed the fact that in both of the cases that I have filed in Pennsylvania, they've involved constitutional challenges to statutes. And in those cases, you get to begin your case in the intermediate appellate court's original jurisdiction, and then you have an automatic right of appeal to the state Supreme Court that is not discretionary, so they have to take it. And I like that because it funnels kind of purer questions of constitutional law quicker on up to the state Supreme Court and puts it more in the hands of appellate courts earlier, so that you're not having to do multiple appeals on maybe a novel question of law or something like that.
That's fair. And I wouldn't say that like I'm all just down on state courts. I think that they're just different, and their experiences don't have to mirror the experiences of federal courts. And there's plenty of, challenging aspects of federal court too. And I wouldn't say otherwise. But one thing I do like about some of the state courts, certainly not all of them, is that some of them have everything searchable online. And so you can find filings in other cases that you don't have to pay, 30 cents or 18 cents a page, whatever Pacer charges these days. You don't have to pay for it. You just go and access it. And of course, the opposite side of that coin is some courts still require paper filing. So there are no online searches at all. So that's frustrating. But I don't know. It's just, it's a different kind of experience. I think one thing that will just never not be weird to me is, and I've only seen this in state court, people sitting while they're talking to the judge, like while they're addressing the court, they just sit. And I'm like, why aren't you standing, sir? This is strange. and I had one oral argument once where like I went first. I stood up and I made my points, and then I sat back down, and my opponent was slouching while he was making his points, and the judge was like, you know what? No, I liked how she stood up. You stand up now. And it was just it was so bizarre to me that in some places they're just very casual about it, which is not my experience.
Was the sloucher upset that he had to stand in your presence?
He was upset about a lot of things in that particular argument. But yes, he was like, well, this isn't normal. And I'm like,
yeah, it sounded like you started a cultural change.
Well, maybe.
Can I get one more shot in at state court stuff?
Of course, yeah, as many as you want.
The thing that I have found vexing at times is like really make you feel like an outsider if you're not like a local practitioner. And at IJ, we practice all across the country. So, while I'm North Carolina licensed, I practice in Tennessee, Pennsylvania, Texas, South Carolina, you name it. And I don't like the procedure of, I've been ambushed by this a few times. You go, it's typically state trial courts where this happens. You go, you're there for a hearing. Doesn't matter how substantive or procedural the hearing is. And you're there for, you've prepared your argument and you're ready to do your side of things. And your opponent will kind of get up and be like, judge, I brought this like handy dandy binder full of like special materials for you. And I'm just going to hand up like, here's like the cases you need. And I'm going to highlight and annotate them. Like, here are the pages, like yellow highlighter for this stuff, orange highlighter for this stuff. Here's a cheat sheet of like all the relevant quotations from those cases on page 1. There's a little table of contents for you. And it's just like it's not an extrajudicial filing, but it is basically a filing of documents with the court outside of the typical briefing process to which I had no notice. And I do not like that one whit.
I would not like that either.
Yeah. It sounds like there's one of the things that if there's a positive, there's some judicial economy in being able to jump over the appellate courts, because I know that Iowa has that similar process where it gives the Supreme Court discretion of just kind of bringing it up. But outside of that, I feel like some of this is summarized by a story that I think it was my civil procedure professor told me when I was a law student, that she had a friend who said that he only practiced in state courts because he liked wearing his brown suits. And he didn't want to have to buy a blue suit or a gray suit. And he said, in state court, it's more acceptable for me to wear my brown suit. And, maybe that encapsulates it.
I think you hit the nail on the head.
Yeah.
So speaking of other interesting rules, one topic that's often in the news and frequently an issue in litigation is stare decisis. For our non-Latin speaking listeners, you know that attorneys love Latin. Stare decisis is Latin for to stand by things decided. And it's basically the idea that precedent matters. And one of the justifications for stare decisis is that courts should respect earlier court decisions about similar issues. And usually the justifications are things like to create consistency and reliability and to prevent a whipsawing between conflicting views of the laws whenever there's new justices on a court. And in our legal system, at least, people usually talk about stare decisis in kind of two senses. There's vertical stare decisis, which is lower courts being bound by higher courts precedent, and then horizontal stare decisis, where we're talking about a court being bound by its own precedent. I think most of the time in the United States, when people are talking about stare decisis, they're talking about horizontal stare decisis, specifically the U.S. Supreme Court's interaction with its own precedent. And there are a variety of ways to think about stare decisis and why, how, and when the court should overturn or modify its precedent. And Diana, I'm curious to hear what you think about stare decisis in general, and specifically the role that it plays or should play in constitutional decision making.
Yeah, so I will start with my priors. I am a skeptic of stare decisis. And I'm not saying always. I'm not saying there's never a role for it. But I think that the roles for it are perhaps narrower than sometimes courts suggest. And so, going along with what you were saying, there are some really good reasons for it, right? It protects reliance interests. It reduces incentives for challenging settled precedent, which in theory saves the expense of kind of continued relitigation of issues that are decided. The courts say that it fosters even-handed decision-making to make sure that, cases are resolved in similar fashion. It contributes to the integrity of judicial process, and it restrains judicial hubris, reminding us to respect the judgment of those who have grappled with important questions in the past. And I think all of those, on paper, that sounds perfectly fine. And you certainly, humility is good for all members of the bar, whether they're sitting up in a chair or down, standing up, making their arguments to the bar. But I don't think that that should stand in the way of making the correct decision. And courts have said that stare decisis is at kind of its weakest when the courts are interpreting the Constitution. And I think that's right, because, to the extent that a reliance interest, it exists, it's, I think, most important when you're talking about contract interpretation, right? Where the courts say, all right, here are some rules for how we are going to establish, or how we're going to interpret contracts when they come before us. And that's helpful to know so that when you go out and write your contracts, you can have that in mind and say, okay, well, if I'm going to make a list, for example, of things that are covered by this contract, I'm going to make sure that I either include every single example of it, or I do not make a list that includes examples and doesn't indicate that is the only list, right? So that you're not in a situation where you've given 10 examples, but it's really meant to include 2 other things, and the court's like, well, you've already included these 10, so that must be it. That's the kind of reliance interest that I think is helpful. But I don't think it's independently valuable in constitutional cases. When a decision is wrong, it should be overruled. I don't think that should be a controversial statement. Korematsu was wrong the day it was decided, and it was correct that the Supreme Court overruled it, even though it was in 2018. Plessy v. Ferguson was wrong the day it was decided, and it was right that Brown v. Board overruled it. And I don't think anyone who defends stare decisis or has a broad version of stare decisis's importance in litigation, I don't think any of them would say that it must always exist, and that, Plessy would, once Plessy's decided, that's it. I don't think anyone would defend that. But I don't know where the line is if you're saying that stare decisis has an important role to play in constitutional interpretation. There's also no other great way to kind of overcome what the courts have said about the Constitution other than amending the Constitution. And as we all know, that is very, very difficult.
Yeah. Josh, you have any thoughts about that?
Yeah, I have a few. So I guess maybe my entry point here would be, it feels like stare decisis is a concept derived from a different conception of law than the kind of law American law is. Right? So English common law is an organic, evolving thing. And in that context, where legal principles governing things like contracts and torts are evolving over time and iterative, they rely on past data points to generate future data points. And the kind of lodestar is consistency with the past to generate the future, right? That's kind of how common law doctrine evolved in the English system. And there, stare decisis makes a lot of sense, because if you don't have a quote unquote law, there's no kind of objective source of it. There's not a statute, there's not a constitutional provision. It's just sort of the penumbra of what came before. No ire directed at that concept. It makes a lot of sense to say, you can't just say we're not going to follow some of the past data points when generating the future data points. So for me, in a purely common law system where the law is an evolving kind of organic thing, stare decisis makes a lot of sense, because otherwise the system can't evolve at all in a coherent way. And for all the reasons that Diana gave, that defenders of stare decisis will offer uniformity, orderliness, reliance interest, that kind of thing. It makes a lot of sense for those kinds of legal questions. But for things like statutes and constitutions, they're really not these evolving things, right? They're supposed to have, whether you want to call it fixed meaning or not, they're supposed to have a meaning. And the meaning, at the very least, begins with what the text is, right? And we can talk about whether context is also part of the meaning. But I would say that at the very beginning, you just kind of start with what the text says, and your task is to figure out what that means. And in that context, stare decisis seems to have less a role to play unless we're talking about something that is truly ambiguous. So if we've got an ambiguous statute, and there's a body of law precedent that kind of develops around the ambiguity to kind of provide some guidance for the citizenry. Like, people have to know how to act based on the statute. Like, courts can create a body of precedent that fleshes that out. And so in a context where there's truly no answer to what the text means, and you're developing precedent to provide guidance on that, it would make sense to follow some degree of stare decisis, unless maybe future evidence comes out that sheds light on what the meaning is, right? But if it's truly ambiguous and there's never going to be a resolution of that without Congress coming in or the voters, amending something, it makes a lot of sense to me to have some kind of stare decisis-based system, so that what people are looking to for guidance in terms of how to follow a statute is not dependent on who happens to be on the court that day. Now, in terms of constitutional interpretation, where sometimes there's just a demonstrably correct answer to the question. So I'll just give you an example. I'm a little biased here, but I have a case pending before the Pennsylvania Supreme Court. Honestly, the sole and potentially dispositive question in the case is just what one word in the state constitution means. And the thing the court was deprived of when it issued a precedential decision on that question in 2007 was any briefing at all on the meaning of that word. And so the court just sort of said something. There was no textual analysis. There was no kind of like historical inquiry into how people at the time used that word. There was just kind of nothing from a definitional perspective. And so we're coming in and saying, look, we have this treasure trove of evidence for you on what this word means. We're correcting the errors of the past. We're filling the gaps in the party's briefing from before. And you have a chance now to get this right when it was egregiously wrong. So in that context, I would say stare decisis shouldn't have any bearing at all, because there's really no point to adhering to a decision that is demonstrably incorrect. And the final thing I'll say about this is that there's a little bit of tension between the party presentation principle and the court's duty to get stuff right. I mean, in this past case I'm talking about, if the parties didn't give the court any of the evidence it needed to get the question right, and the court abides by the party presentation principle, which is that it's only going to consider arguments and materials offered by the parties in resolving a case, why on earth should we respect that decision if it's the outgrowth of totally deficient briefing, right? So that's kind of my quick thoughts on that.
Yeah, it's all super interesting. I think something that you said, Josh, in the beginning that I think I'm not sure that everybody thinks about when we're talking about stare decisis is that stare decisis is a concept from another, not just area of law, but a kind of a type of law that pre-existed the written constitutional American system. And it does seem like that has a real consequence. And I think that you also see this in, certain Supreme Court justices, if they think more like a common law justice, like that has consequences for how they think about the Constitution. If they think more of in kind of a deductive way, it influences how they think about the Constitution. And they are really different ways. I mean, the common law is kind of, you accumulate all these data points over time by deciding these particular cases, and the principle only kind of arises out of them as time goes by, right? And you kind of start to understand what that principle is and what the contours of it are. And then later you might have a legal treatise that tries to actually pull those principles out of the common law to create some kind of rule or to consolidate things. But that's not what the Constitution is. Like, the Constitution is starting with a principle. Often it's things that have been derived from history, but there are principles. And that isn't really described as a principle that's supposed to evolve every time it's applied. It's going to be extended in new ways. It's going to be maybe applied in ways that are surprising, but the principle itself is one that's kind of already there. So you're using a different type of reasoning to apply constitutional principles than you are reasoning through particular common law places. So I think that's kind of interesting.
One thing I find a little interesting too is that, I think sometimes stare decisis can be kind of outcome driven, right? And that, I think that a justice or a judge who recognizes that they might be in the minority on a particular issue might find stare decisis to be something to cling to so that their preferred precedents aren't overturned. And that sounds a little cynical, and perhaps that is too cynical. But I think also judges are being in a world where law is being made every minute is uncomfortable. It's uncomfortable for the parties. It's uncomfortable for the judges. I find it fun, actually, because it's like, look at all this cool stuff we can do and figure out as we're working. But right now, for example, Second Amendment case law is new all the time, right? And it's judges are figuring it out as they go. And in this, post this Brahimi world that everyone seems to...
Shout out to AO.
I know, I like it. So I'm David Latt's using it and AO's using it, so I think it's settled. But as the courts are figuring it out and applying it, it's, there's going to be a lot of wrong decisions, right? And we're going to be kind of bouncing up against the edges, and what's right and what's wrong. That's an uncomfortable spot to be in. So I understand why judges are like, well, can we just apply the law that's already been written rather than, this whole new world? But look, I mean, if Heller was right, if McDonald were right, if both of those cases were right, we're now kind of experiencing what happens when you say, okay, the Constitution protects this form of liberty, go out and figure out what that means in terms of the law. It creates some instability, I suppose, but in figuring out what that means, but that's the nature of the law.
Yeah, I don't think that it's cynical to point out that, especially when there's you can kind of think of it as a regime change, or it's at least a methodological change, but sometimes feels like when the law has been unsettled in new ways because there's an adoption of a certain methodology, whether that's history and tradition or something else. I think it's inevitable that you're going to have judges who, if they are skeptical of the way that methodology is being applied, stare decisis has to be one of the things that you're going to reach for, right? Because it's kind of the pump the brakes idea a little bit. And it also, that to me makes me think of stare decisis maybe as less of a rule about in what circumstances do you rely on precedent, but maybe just a consideration as justices are working through whether to overrule something that, justices, before you did grapple with this issue, they're smart people. You should assume that they are smart people who grappled with this issue. They may have been applying a different methodology, but you should at least make sure that you are kind of considering that reasoning as you're working through it.
And, one context in which I don't even know if you'd call this stare decisis, but suppose you had a constitutional precedent that, was being questioned in a case, you were being asked to overrule a case and you're a justice. And you sort of say, like, I don't know, like, I see good arguments on both sides. I think it's a close call. In that situation, you probably shouldn't overrule a precedent unless you feel, I don't know, whether you want to call it strongly or super strongly that the prior precedent was wrong. I mean, you should at least feel that the deck is, stacked in one direction and not at least a toss-up. Like, if you're kind of just not sure, if you're equivocal, that might be a context just to say, okay, let's leave the sleeping dogs where they are.
I fundamentally disagree with that, because there's a 152-year-old case that was wrong the day it was decided and that should be overruled, and that's called the slaughterhouse cases. And I feel very, very strongly about that.
But it's not a toss.
Yeah, but how's that disagreement? You're saying you feel strongly, and that's, if you feel like it's...
Because I don't think everyone agrees with me, unfortunately.
Well, but if you're the justice, you kind of have to decide for yourself, and I take it that Justice Diana Simpson would think it's clear and pursuant to the principle I just gave, she'd overrule slaughterhouse. And
you'd butcher
okay.
it.
Okay, I just have to prep for my nomination, I guess.
That's right. That's actually a good, that'll get you the nomination right there. Just a quick kind of addition to that, I kind of feel like, John, you had this question you asked us in the kind of like chat before we hopped on here about like, should the standard for overruling precedent be like wrong or super wrong or extra super egregiously wrong? And I just think wrong is probably the standard. Like, if you have arguments that to you convince you it is wrong, like that is enough. And this idea of you have to show super duper wrong or something like that. Like, what does that even mean? I don't even know what that would mean to say that it's extra wrong.
Isn't humility recognizing that when you're wrong, you fix it and you take the steps toward being right?
I will give myself immense credit in this moment for style points. And in our briefing in this Pennsylvania case that I've mentioned, and I never do this in my briefs, but I have, what do you call that, guys, when there's like a quote at the beginning of a section that you give?
I don't know, because I don't use that style myself.
Okay, well, I did it this time, and it was a quote from, this is Pennsylvania, it was a quote from William Penn, and he was reflecting on solitude so it's like super relevant to privacy and the issue in the case. And the quote is, if we were wrong, let it be so no more, right? Ooh. And the idea is like, live up to your mistakes, like correct your errors.
Man, if I had that kind of on point of a quote, I would use that style in my case.
I could not ignore it. I could not ignore it when I found it.
Yeah.
Well, for people who want to learn about things as interesting as stare decisis or constitutional litigation, one option is to go into public interest law. And if you're someone like me who, when I was in high school and honestly through a good chunk of my undergrad experience, I didn't really know much about the practice of law, let alone public interest litigation. And both of you have had opportunities as IJ attorneys to interact with students, both undergrads and law students. And so for Josh, just to start, I know that you've gotten questions from students before about the kind of work you do. And could you share just a little bit about the kind of questions that you've gotten and the advice you might give for undergrads or law students who are maybe curious but not entirely sure about public interest litigation?
Yeah. I mean, the questions are all over the map, but maybe I can start with the questions I've been getting a lot recently, because they kind of drove me to raise this as a topic that we might discuss. So I've had a few undergraduate students who are considering going to law school reach out to me in the last few months and make it very clear to me that their desire was to go into appellate practice, like purely appellate practice. And I'm kind of curious where this, it's not really a trend necessarily because it's just anecdotal in my experience, but it's enough students kind of consistently asking me this, and I'm like, what's going on there? And maybe what's going on is that SCOTUS, the Supreme Court, has sort of like become synonymous with the law. Like, if you're kind of a member of the general public and if you know anything about the law, you probably know it through the lens of what the Supreme Court has decided in the last few years on various hot button.
Maybe some celebrity trials outside of that.
Yeah, that's true. That's true. But generally speaking, I think the Supreme Court kind of carries most of the oxygen in the room. And, if the way you conceive of our legal system and legal practice is through the lens of these like major U.S. Supreme Court decisions on kind of hot button issues and through the kind of lens of listening to SCOTUS arguments and kind of consuming that kind of appellate practice, I want to caution that you're really consuming like 1/100th of 1% of what all legal practice is. And of course, it's deeply important. It helps shape our society and all of that. And a lot of us here at IJ would like to argue at the U.S. Supreme Court, and some of us have, not me, unfortunately. But the thing that I want to emphasize is that if you want to go into purely appellate practice, I think that you would be at a disadvantage if you didn't spend a little bit of time litigating cases in the trial court. That's not to say that nobody does it and nobody can do it, but it's probably worth taking a step back as you venture into law school and maybe your first job out of school or something like that, to just get a sense of what trial court litigation is like. I think you'll be a better appellate advocate if you know what a deposition is, if you've cross-examined somebody, if you've, sent or thought about requests for production and done, genuine doc review at the outset. That sort of stuff, I think, helps give you a sense of concretely what is actually shaking out in the trial court and what happened, so that when a case is on appeal, you just got a sense of how the case came to you and how it came to be, that you're litigating this issue on appeal. And I think it probably rounds you out as an attorney. That's not to say you need to spend a bunch of time doing it if you really just want to practice appellate law, but I would just sort of caution folks to try to get a little bit of a diversity of experience early in their legal career so that they can ultimately specialize and kind of pick the direction they want to go. And here at IJ, one of the most awesome things about being an IJ attorney is that we litigate our cases from the day you build the case and interview the client all the way up to whatever the highest court you can get to is, whether it's the state Supreme Court, U.S. Supreme Court, federal circuit court. Our cases are our babies in that sense. We own them from start to finish. And there's really no replacement for being the guy who took the depositions in the case or the guy who had the trial. When you are standing before an appellate court arguing about that case, I'll just give you one example that is sort of my favorite. So I do a lot of cases involving government trespassing on private land, and the cases typically turn on things like, what are the features of the property? Like, what is the property like? And I'm able to say, on appeal that I've walked that property. I've seen that sign with my own two eyes. I've opened that gate, right? I know where that barn is. And to me, that just puts me in such a position of advantage over my opponent, who is taking over the case often for the first time on appeal and truly just knows the property as kind of this academic quantity. He's never been there and he never will. And I appreciate that at IJ we get to have that well-rounded experience.
Yeah, Diana, I know that you've also interacted with a lot of students. Have you received similar kinds of questions, and what advice would you give to undergrads or law students about public interest litigation?
Yeah, I mean, so I when talking to undergrads, I think there's a lot of uncertainty about whether folks even want to go to law school at all. They're like, oh, well, it seems interesting. It seems like it would be a good way to learn about things and expand opportunities. And I suppose, but law school is deeply expensive. And so I always like to tell undergrad students, look, I'm a lawyer. I could not be doing what I am doing without having gone to law school. I appreciate that I went. I liked what I learned. But I always tell law students or undergrads that if they do not want to practice law, they should figure out what they want to do first and then just read about the law otherwise. There's plenty of material. There's plenty of ways that they can learn without going and sitting in an evidence class and being told about evidence by a professor who hasn't actually practiced law, for example. And that's not to denigrate law school. Like I said, I enjoyed my experience and I'm glad I went. But I think that is a very roundabout and expensive way of figuring out what you want to do. If you want to be a lawyer, you should go to law school. But similarly, like when law students say that they want to practice public interest law, and that's like the only thing they want to do, one thing I say is, if you want to do it, then absolutely do it. Go and get experience in your summers and your semesters doing public interest law. There are clerkships that you can do, and not for judges. I mean, well, you can do clerkships for judges, but specifically, I mean, you can clerk for the different public interest firms and spend a summer there, do a semester there. All of that, I think, is a very helpful way of both getting the experience and seeing if that is actually what you want to do, but also demonstrating that you are interested in it so that when you apply for a position, it's not just kind of out of left field. You show that you are indeed interested in it. But I also, the practice of public interest law is the practice of law in regular ways too, right? Like a trial advocacy class is helpful to an aspiring public interest litigator. And evidence is critical no matter what argument you're making if you are in court. And so do those experiences, take that. When I was in my third year of law school, I did an immigration clinic and I did an externship at the AG's office. And so I was able to stand up and talk to a judge, 3 days a week, which was totally weird for me. And that gave me experience standing up in front of a judge advocating for my client. The immigration clinic was very helpful. I talked to clients and wrote briefs on their behalf and found the holes in the law that I could advocate for. And so public interest law is kind of like that, except you're then trying to make precedent, right? And that's, so those experiences weren't necessarily public interest in the way that I practice it today, but they gave me that level of experience so that when I started as a fellow way back in a year, but when the dinosaurs roamed the earth, that was something that yes, I was on day one, but like I had some kind of understanding based on what I'd already done.
And just to piggyback on this whole thing about gaining experience and kind of like concrete understandings of what the practice of law involves as early as you can. I mean, I think it's one thing to say you want to go into law because you find the law kind of interesting, and often, again, that understanding is guided by a lot of folks who want to go into public interest law by what kind of the Supreme Court's up to. But I would say that if you're an undergraduate student considering going to law school, you should find a way into a courtroom. Go attend some kind of argument at your local state court of appeals or state Supreme Court. Go ask an attorney that you might have a relationship with or build one to go spend a day in their office and kind of see what it's like around a law firm. I had an opportunity super early on. I think I was probably a senior in college at the time to go attend an argument by the Charlotte City Attorney and a retired state Supreme Court justice. They were co-counsel on a case involving a dispute over the Charlotte Douglas International Airport and what entity within the state controlled it. Was it the city or was it the state? And that was super cool. Just to go attend that hearing. It was packed with reporters, so it was a little bit bombastic, but got to see arguments in court and kind of what that looked like and how a trial court judge interacted with counsel. And that was a formative experience for me because it gave me a sense of what practice of law looked like in real terms. So kind of get those experiences and collect that data so that you can assess, do I want to litigate? Do I want to be an in-house counsel? Do I want to do X or Y type of law? Because it's one thing to think the law is cool. It's another to say, I really want to do the tasks that the practice of law involves, which is, often taxing and difficult. But if you like it, then come to IJ.
Yeah, and one thing you can do is all the oral arguments from the Supreme Court are online. Maybe not all, most of them. They're on OIA's website. And so back in the day, I used to listen to oral argument while I would do my long runs. And so I distinctly remember, this is one of the nerdier things I've said, when I PR'd my half marathon, I was listening to Citizens United oral argument. That was very interesting to me. So anyway, just throwing that out as a possibility.
Yeah, and I think that the thing that Josh started with about getting comments from people about being interested in appellate work, I think I interpret the same way. It's like when someone says that, my assumption is they're probably following Supreme Court stuff and they find the ideas interesting. Like they find the war of ideas and these nitty-gritty, usually constitutional issues very attractive. And I think that sometimes leads people to think that doing the trial court work, whether it's depositions or doc review, or kind of whatever the nitty-gritty things are, to put it cynically, maybe beneath them if you're interested in only the appellate work. And I totally agree with what you were saying, Josh. Like, whether you're going to do trial or appellate work, you are just a much more dangerous attorney if you kind of have the whole experience, and you've been in the deposition, and you've had the kind of the boots on the ground stuff. Because otherwise, it is an abstraction. And to be fair, there are plenty of people who do just appellate work, and there is a point at which it is an argument about kind of abstractions. But it is such a legal practice is such kind of a rich spectrum of things that it'd be a shame if people kind of only looked at appellate practice. Also because there's very few people who just do appellate practice in those constitutional litigation areas. And then something that Diana said about getting this experience, I wonder, I'm sure there's people who have looked into this, but I have the impression that the kind of clinical, practical experiences have increased in frequency in law schools. And my law school had we had a ton of clinics, and they were awesome. They were the first places where we were able to interact with clients, work on briefs, and do all the things that lawyers actually do. And Josh, like you were saying about going into a law firm, I don't think a lot of people do that before they decide to go to law school. And I think what you miss out on is what the day-to-day looks like. And that's particularly problematic when law is one of those professions that I think has an image, like in the culture. There's TV shows about being a lawyer. There's books about being a lawyer. And I think a lot of those depictions of being a lawyer, they obviously don't capture the nitty gritty things. They don't capture the day-to-day life of actually being a lawyer. Maybe Better Call Saul in some ways does.
Well, especially not being, just to kind of brag a little bit on IJ, especially not being a public interest lawyer,
right?
Where we are sitting here recording a podcast about the law. We are sitting here in our offices where, we sometimes hop on calls with reporters about our cases. We're down the hall from a studio where, we can record live TV interviews about our cases. Like I mentioned earlier, often we do site visits at our clients' properties or at like whatever the relevant site is for a case, and kind of go out into the real world and see what the case involves with our own two eyes and often hands and feet. And that's awesome, right? Like our job is very hands-on in a lot of ways. It's very diverse. Being a public interest litigator is not at all like a one-stop shop type of thing where you just do briefs or you just do arguments or whatever. John, as you know, like I'm working on a tiny little law review article right now. And like, that's just kind of all the things that we do in public interest law make it rich, make it fun, make it exciting, make it varied. And you just don't get that in other types of legal practice. You might get it in kind of fits and bursts in different ways, but I think one of the things about public interest law, it's so nice, is that it's extremely varied. And so there's kind of something for everybody here.
For sure.
For sure. Yeah, so to close up, our listeners are always curious to know what you're listening to, reading, watching, etc. And if you could maybe mention one law-related thing and one non-law-related thing. If you'd like, I can go first.
Go ahead.
If you want to think about it while I go, because I do have two things that are on my mind that I just kind of wrapped up.
Go ahead.
The first thing, the law-related thing, is I just finished reading Professor William Cudahy's massive treatise on the origins and original meaning of the Fourth Amendment. I'd read pieces of it here and there over the last few years, as there would be a particular topic, usually in a case, that I was interested in kind of running down. But I wanted to actually read it from cover to cover, and that's been quite an experience. It was originally William Cudahy's PhD dissertation that was never published. And then in 1990, or around then, it was published. And there was like these 4 volumes that it was published in. So people who were studying it, they had to lug around these 4 volumes of this PhD dissertation. And then in 2009, with some changes, it was consolidated and published in this big book. It's an enormous book. The book spans from 602 to like 1791. And it's just about the origins of the Fourth Amendment. It's about the common law. It's about how the English started to think about what it means for searches to be unreasonable and how that was attached to general warrants, and eventually what happens in the colonies. And the role, I think that this is one thing that's in the book that's not always on the forefront of people's minds, is the role that the Fourth Amendment played in or the concerns that led to the Fourth Amendment played in inciting the American Revolution. So it was an incredibly interesting book. It is very, very dense. So it's not a narrative story about all of that, and it jumps around historically, but it's kind of a tome of Fourth Amendment original history, and it has so much in it that I suspect it'll probably take many more years for people to extract value from it, more value from it. I think that people will kind of continue drawing on it and finding new things. And I bet that lawyers and scholars and judges will be citing it for quite a long time. It's already cited pretty regularly in opinions and articles.
And just to interject briefly on that, he recently passed. I think it was last year. So RIP
2023.
to Professor Cudahy. But appreciate all his amazing contributions to our understanding of the Fourth Amendment. Yeah,
it is probably the most ambitious Fourth Amendment scholarship ever done. It's incredible. My non-law thing is that I just also related to someone who just passed. I just finished the first 2 seasons of Twin Peaks, and it's technically a rewatch. But when I watched it the first time, I kind of had it on while I was doing things. I was working, and I kind of missed some of it. And so when David Lynch passed, I think last month, I think it was in January, it reminded me that I really enjoyed the show and I wanted to give it my full attention. And I'm glad that I did. If you've never seen Twin Peaks, it's this really unique, to put it kindly, combination of like a small town whodunit murder mystery combined with some very surreal, otherworldly stuff. And the craziest thing about all of that is it aired as like a primetime soap opera in 1990. And it's interesting to watch it closely because if you've seen some of the big shows that came after it, like X-Files or Sopranos or Lost or True Detective or things like that, Twin Peaks influence is all over those shows. So I enjoyed it both because it's great. I loved it. But it was also interesting to see the impact that it's had.
I love the X-Files. Haven't seen
it's
Twin
great.
Peaks, but yeah.
It's so good. It's one of my like core childhood memories is watching the X-Files.
Same. I don't know, Diana, you want to go next or I can go?
Sure. So for my law thing, we just filed our opening brief at the Ninth Circuit about, on behalf of a woman named Norma who shares food that she makes at home with people who have nothing to eat. And she, for this, great thing that she was doing, she was arrested. And so we're challenging the ordinance under which she was arrested as violating a fundamental right to engage in charity. And so we just filed our opening brief. It's quite the tome. And we trace kind of the historical exercise of charity. And so not just in the United States, but kind of from Anglo-American roots, through. And it's been, it's fascinating. I mean, it's there throughout. It's often religious, but not always. And so there's just like so much cool stuff to read on this topic. And one of the things I really enjoyed reading was a book about the Underground Railroad, from slavery to freedom, by a guy named Wilbur Siebert. This was written in the 19th century, and it just traced all the different things that Americans did for others in kind of one of the most horrible parts of our history, to see these people who were doing the right thing consistently and at great risk to their own livelihood. It's an incredible read, and I recommend it. And it's not just about letting people use your house, which of course is an enormous undertaking, but it's about all the things that people did for others, even if they were small or big, or leaving food, or all of these things. And so that's something that certainly we wove through our opening brief and had a lot of fun talking about, but it's just a good reminder of how inherently good and helpful Americans are to others.
Can we link your brief in the show notes? That'd be awesome.
Happily.
Yeah, we'll do that.
And so then for my non-law thing, I feel like world news right now is drinking from a fire hose. So I'm trying very hard to avoid it for a brief window of time every day. And so we've been watching Bad Monkey from Apple TV, which is delightful. And so Vince Vaughn is basically he's now a health inspector. He used to be a detective, and things went badly for him. And he's in Key West, and he's investigating a case where they find a human arm. And the idea is that it was the remains of a guy who was chopped up by a propeller or eaten by a shark or something. But was it really? And so anyway, it's a dark humor kind of comedy drama, and it's so fun, and it's a really nice retreat from the world being on fire right now.
It's awesome. I have a cop out on the legal one. John, in preparation for this, you sent us a note in the Harvard Law Review titled "The Incompatibility of Textualist and Originalist Approaches to Legislative History." And I read it, and we didn't talk about legislative history, so I will briefly comment on it and say that I messaged you about this, but I'm a big fan of the kind of like conclusion of the article. And not to rehash the whole thing, but the conclusion is fun. So the author basically says, and I wish I knew the name of the author, by the way. I couldn't tell from, I don't know if it's their convention.
It's because it's a note. Yeah, it's a student note that doesn't have a name on it.
Yeah. So I mean, whoever you are out there, appreciate your good work on this.
We'll link your note in the show notes.
Yeah, and I the conclusion is fun. So basically the premise of the article is like, hey, there's these textualist originalists out there. They kind of dominate the court right now. And they seem to hate legislative history when we're talking about statutes, but like, hey, they treat the Federalist Papers as super important when interpreting the Constitution, and that's legislative history. So what's up? Like, why the dissonance between the two? And the conclusion the author reaches is effectively, if we're going to try to reconcile these two approaches, like one way to do it would be to say, let's consider the legislative history for both statutes and constitutional provisions that tell us about the mischief the statute or the provision was designed to remedy. And like, I'm not going to sit here and pontificate about all the different ins and outs of legislative history and originalism, but what I will tell you is that I'm a big fan of this idea that mischief matters in interpreting statutes and the Constitution. At the end of the day, these things are adopted to do something, and like, we should really care what the thing is that they're trying to do. You know, if the Fourth Amendment was adopted, as you mentioned a second ago, John, in response to the problem of general warrants, we should kind of know what a general warrant is and what's going on there. So I'm a big fan of this idea that mischief matters, and I appreciate the note for kind of highlighting that. The non-legal stuff, I will give two answers. So one is, it will take me 4 seconds. So I'm a metalhead. I like this band called Valhalla. They do something called folk metal.
It's not by any chance Norwegian death metal, is it?
No, it's not Norwegian death metal. They're actually Australian, and you spell it Valhalore. The band is awesome. They have a new album coming out in April, but they released a single called Wayfinder, Wayfinder, and it's a ballad. So it's not like heavy screaming stuff. If you're super new to metal or you've never listened to metal, never heard of folk metal, like, go type in Wayfinder on YouTube, listen to this song. It's very touching. The lyrics are about love and life, and it's just beautiful. And I've listened to it a lot of times over the last few days, and it's worth a listen if you know nothing about metal.
We'll link that too.
To open your mind a little bit on that topic. And then the other thing that is sort of non-legal that I'm consuming right now is a book called Good Energy by Dr. Casey Means. It's kind of like in the vein of Peter Attia's Outlive, if you're familiar with that. It's one of these kind of like hot health books right now. I will tell you that I'm about a third of the way in, and I'm a little skeptical of books whose like main thing is, here's like one answer to every health problem, right? But I do like a basic idea that the book has put forth so far, which is like, the problem with medicine as it's practiced today is so many of the treatments that we receive are treatments for symptoms that are downstream of life habits. So like, you have a 60-year-old who comes in with a heart attack. It's like an acute situation. Well, why wasn't the medical system involved, or why weren't they involved as a patient in like managing their health in a way over the last 30 years to kind of avoid being there in that moment? And so, you know, there's so much of health that is remedial, that is responsive to acute problems. And so what Dr. Means kind of, I think, is offering in this book is a way of thinking about health that is an ongoing enterprise, that is not the sort of thing that you should just think about when you show up at a doctor with an emergency, but is instead a day in and day out endeavor that involves diet and exercise and all the rest. And I really appreciate that perspective. So TBD on what I think of the whole book, but I've liked it so far.
So I loved it. I finished it a couple months back, and I think it's really fantastic. You know, kind of the premise, I'm not giving anything away, but the premise of it is that, you know, we all have to be metabolically healthy, and that the ways to do that might be what you imagine: fewer Oreos and you know, more spring mix salads or whatever. But she does kind of go through a lot of the data while also talking about material in a kind of, in more of like a just an easier way to understand, I guess I should say. And so I really enjoyed the book. I read it when I was on maternity leave with my last kiddo, and it was just it hit home in a lot of ways for me. And it talks about, you know, kind of some of the incentives of the medical system and how they might not always be aligned with actually resulting in better health for us all. And, you know, maybe we can take the reins and figure it out ourselves.
Sounds super interesting. All right, well, thank you, Diana, Josh, for coming on.
Thanks for having us, John.
Of course. And I hope that our listeners enjoyed the show. Go listen to some folk metal, read, what is the book called? The healthy book?
Good Energy.
Good Energy. Read Good Energy. Learn about stare decisis. And tune into our next episode for a new rotation of esteemed guests and clever opinions. And until then, that's just like your unpublished opinion, man. I'm gonna do like a Chinaman.
and get some hops, get myself a gun, and shoot